court, I appear together with Mr. Diedrichs and Mr. Perimal Sami on behalf of the applicant, that's the Independent Patriots for Change. I'm Anton Katz from Cape Town.
My lady, subject to rejoinder, I appear for the second applicant, together with Mr. Lovindao, Ms. Shuweda, and Ms. Paulus.
Ladies and my lord, I appear together with my learned junior, Dr. Akwenda, on the instructions of the government attorney for the president, the first respondent.
Mr. Heathcote, thank you.
May it please you, my ladies, my lord, I, together with Mr. Nekwaya and Ms. Shivotoka, appear on behalf of the second and third respondents, that is the Electoral Commission and the Chief Electoral Officer.
Thank you, Mr. Narib.
As the court pleases, your ladyship and your lordship, I appear together with my colleague, Mr. Gaib, Mr. Kazondwana, on the instructions of Sisa Namaj and Company, and we are representing the fifth respondent, Swapo Party of Namibia. Let the court please.
Thank you, Mr. Namanje. Good. Council, good morning. We have already met in chambers, so good morning again. Just housekeeping. As the court indicated, or you will remember that you have received a direction from this court yesterday requesting the parties to address the issue of a possible stay of this application pending the outcome of the challenge that's served before the Supreme Court. So we have received some notes of you, Mr. Katz. Thank you very much for that. But before we proceed on that specific issue, we intend to address the issue of security first. Mr. Heathcote?
No, I'm just standing. If the court, I see all of us are sitting. I don't think that's appropriate.
Agreed. So we will deal with the issue of security first and foremost, to be in compliance with the Act. Whereafter we will then adjourn for the court to consider the issue of security, and once we then reconvene, the court will then give further directions regarding the how we proceed forward.
Please, Your Majesty.
Thank you. Mr. Heathcote.
Yes, my lady, there were some, on the cost aspect, some correspondence during the preparation and obviously having regard to the legislation itself. We were offered by the IPC 25,000 and we demanded 500,000. I respectfully submit that between us, at least, the entitlement is not in dispute, it's only the quantum. We did forward to the registrar a request, but let us deal with it now. The best example I have, and my learned friend for the commission will deal with it, is when in the previous Supreme Court matter of Mr. Itula, you will recall that the government was ordered to pay their costs. Now, you will also know, my ladies and my lord, the Supreme Court taxation is a bit of a dismal backward in time, but eventually 680,000 was taxed out.
680.
680,000. The allocator, I understand, is here, but of course I cannot now raise my 500 to 680. I stand by the 500. I say that the same must be applicable to the landless people movement. Thank you, my lady.
Thank you, Mr. Heathcote.
I have a copy of the allocator that is referred to by my learned friend for the first respondent. perhaps as an indicative figure, if I could hand a copy to the court, the amount that was actually taxed out in that matter is 888,137.66 cents. 888,137 Namibian dollars and 66 cents, and that was in regard to a relatively not so complex matter where there were two counsel involved and one instructing counsel. The matter is the case of Panduleni, Philemon Bango Itula, and others. This is the Minister of Urban and Rural Development and others. There's a Supreme Court matter, case number A1/2019. A1/2019. I have copies here, my ladyship, your lordship, as indicative figures, if the court wants to regard those copies.
Thank you.
Your ladyship, there was some debate, I don't know the extent of that debate, on the liability of the applicants to provide security for the commission's cost. I'm anticipating that may arise when my learned friend for the first respondent comes up to address that issue.
First respondent to first the applicant?
First, the applicant, your ladyship. I'm not so sure, but I will address that if it is an issue, but I know that this court has previously ordered or indicated that security is payable in respect of the commission's cost. I unfortunately do not have the court order. I was trying to obtain it from the court records, but it was a case EC3 of 2020, Workers' Revolutionary Party. This is the Minister of Urban and Rural Development. The issue of cost was raised ex modo by the court. Security for cost was raised by the court, and the court would not proceed until that security issue was addressed in a Workers' Revolutionary Party matter. So, your ladyship, my lord, the first respondent is asking for security in the amount of 750,000 Namibian dollars. This was communicated to the applicants.
Sorry, Mr. Narip, you say the first respondent.
No, the second respondent, pardon me. Second respondent. Second and third respondents already. 750,000 Namibian dollars. There are 3 counsel retained in this matter. It's a sufficient complexity of the relationship, and we submit that such security is warranted in respect of both applicants in the matter. Your ladyship will notice that the allocator that I have handed up was for at least 2020 or around there. We are some 5 years down the line, and that was for 2 counsel, and then I instructed counsel. I will address the issue of liability for security once it is raised.
Any questions? 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 Thank you, Mr. Narip.
Copy.
Mr. Namanje.
My ladies, your lordship, first, I appreciate the assistance that the Council for ECN provided to the parties and court to make available the advocateer in the Supreme Court. And I do agree with Counsel for the President that it is a known fact that the rates of the Supreme Court in comparison to the rates of the High Court are quite lower, and in other words, the factual material by agreement placed before court is material to the court determination of the quantum. In addition to that, briefly, I just want to highlight the fact that with respect, it must be avoided that the provisions relating to security expressly stated in the statute must not be a dead letter. It must be it. It's security. It is not symbolic. The amount must be in fact and in substance represent security. So in respect of the SWAPO party of Namibia, Your Lordship, you would have seen in the papers that we are going to seek a punitive order. We have motivated in our papers as to why we will be seeking a punitive order against the applicant. That being the case, Your Ladyship and Your Lordship, we invite the court to keep that in mind, because when the court is considering cost, we have justified, for instance, in respect of the abandoned irregularities, that our client cannot be out of pocket. Because of that, Your Ladyship, Your Lordship, we are seeking an amount of 600,000. I'm appearing with two juniors, Your Ladyship and Your Lordship.
Just one thing. Notwithstanding the punitive costs sought by your client, I think one must then also be mindful that security should not constitute literally closing the door to a litigant.
I do, but the scheme and the structure of the relevant section on the cost, Your Lordship, there is a section that provides that, notwithstanding the fact that this court can only grant cost in certain respect, security, there is an overriding statutory provision that security must be paid. So in other words, the legislative policy is that a client, a litigant such as SWAPO party coming to this court, as a matter of fact, and in law, there must be security provided for. Obviously, it's not. We are not saying it's a bar.
Yes.
It's going to be a bar. Remember, your Justice Sibert, to the extent the applicant was hamstrung by the provisions to provide security, it was open to provide to institute an application to be absolved from the obligations to pay security. So in other words, the court cannot start managing the provision in such a way as if the legislature has not already made provision that if you are unable to pay security, you can approach the chairperson of the court to be relieved from obligation to pay security. So we are not saying it is a bar.
There's no application to be absolved from paying security. We don't have it.
Yes, exactly.
So security must be paid.
Exactly.
The issue I raised is that once the security amount is set excessively high, will that not constitute literally barring a party from approaching court?
Oh, with respect to your Lordship, Justice Bear, nobody amongst us is asking an excessive security. It's exactly what is provided for in the Act, that an applicant must provide security for costs that may be incurred by a litigant such as the SWAPO Party of Namibia. If those costs end up being excessive because, amongst others, a litigant like IPC approached this court with thousands of irregularities and the hearing there is one, that is a fate they must suffer and the consequences they must suffer. So we are not asking, that's why we provided, for comparison purposes, the Supreme Court rates, Your Lordship. Those are my submission on the question.
Thank you.
Justice Sibert, Your Lordship. Thank you. That's the court.
Any questions?
So my colleague is reminding me our amount. We said 600,000. That's the court.
So what you're saying, Mr. Namanje, the offered 25,000 is merely a token.
Basically, anybody who has a rudimentary knowledge of how litigation in this country works would immediately ask a question, what do you mean, 25,000? Even just copies of the 3 files I have, Your Lordship. So that's why we are saying that the provisions must not be dead letter. It must not be a token amount. It must not be symbolic. The legislature said they must pay security, and that is it. If the law is bad, we can't think it away. They must attack the constitutionality of the law as a bar to them having access to justice, Your Lord. That's the court.
Thank you, Mr. Namanje.
Lydia, I have 2 broad comments. The one is a submission, and then the other is a suggestion. The submission is, on the assumption that the court is inclined to grant security at all, the amount should be 0. I'll explain why. The comment is that were the court to reject my submission, the principal submission that there should be 0, my instructions are to suggest that the court order 100,000 in respect of each of the 3 opposing respondents. And let me start off by giving you my reasons, my submission, as to why 0 is the appropriate amount. On the assumption that the provisions of 169 sub 4 of the Electoral Act apply at all. So I'm assuming that it applies. Bearing that in mind, then the court will have to exercise its discretion to come to an amount.
Can you just clarify the words on the assumption that Section 169 applies?
Yeah, I'll come to that.
Please.
Well, 169 applies, but when it comes to 169 sub 4, the question of who it protects, and our primary submission is it may well protect SWAPO, but not the other 2 opposing respondents. But before I come to that, I'll come to that. Why is there such a thing as security? And one has to go back to first principles. And first principles tell us that security for costs is given in order to protect a party who spends a lot of money in defending litigation. They win the case, they get a cost order, and they can't execute. There's their security. That's the idea. So we come to the important section for our purposes, 171 of the Electoral Act. And this court will have to make a prediction, and this is why I'm going to suggest 0. This court will have to make a prediction, and one assumes that the matters set down for today, the court issued a directive concerning the stay, so the court knows what this case is about. We know that the other side have said they've employed all these fantastic counsel, it's a complex case. What does that mean? First principle, this case is not frivolous or vexatious. And that your ladyship, with respect, and your lordship can accept, this case is not frivolous and vexatious, other than in one respect. The opposition is frivolous and vexatious. So let's read 171 together. Despite anything to the contrary in any other law, in any proceeding before this court, the electoral court, the court may not make an order of costs against a party, that's my client, unless, and this court will have to make a prediction about what's going to happen in the main hearing, the party, that's my client, has acted in a frivolous or vexatious manner by instituting proceeding with or defending any proceedings. Now, at this stage, can this court predict whether or not this court will make a cost order when the main case is? Yes. The court won't make a cost order against my client at all. So why bother to make 1 cent worth of costs against my client who won't have a cost order against it made in the main hearing? There's absolutely no purpose, and this court will not do something by ordering an amount which has no purpose in terms of the statute. So that's why I say applying 169.4, which is the security for cost order, taking into account that this court will not issue a cost order against my client in the main proceedings, 0 is the amount. And that's applying 169.4. So you say, yes, we order security, and the amount can be zero, it can be $10 million, it can be anything, but zero is an amount. And in this case, zero is the appropriate amount. We will not have a cost order. It's ordered against us in the main. And the respondent's argument this morning says this is a complex case. They've hired all these counsel. You've read the papers. You've seen their heads. It's not frivolous and vexatious by any means. Now we turn to 169.4, the government provision. An applicant, that's us, must, at the time of the presentation of an application before the electoral court, furnish security for costs, for the payment of all costs, charges, etc., that may become payable. Again, this word may. We say it'll be nothing. We know why, because we're not going to have a cost order against us in the main case. That may become payable by the applicant before the electoral court in there are two, let's call it situations where it applies, to any person which may be summoned as a witness on his or her behalf. Court can strike that out. So we're not in A. There's no witness talking here. This is an application. B. To the person, well, we'll talk about who that person may be, or in the case of an election on party lists, the political party or organization, that may well be SWAPO, whose election or return is complained of. Well, what's happening here? We're not complaining of a return or election in the true sense. What we're complaining of is a proclamation made by the president. The president acted unlawfully. That's our case, by extending on the 28th of November 2024 an election. That's not a complaint about a return or an election as such. It's a complaint about presidential conduct which was unlawful and unconstitutional. Therefore, B doesn't apply, at least in respect of the president and the commission, certainly, and also in respect of party, SWAPO, because there's no complaint about anything that SWAPO has done. How can there be an order under B in SWAPO's favor when we haven't complained 1 second in our papers against SWAPO? So as a matter of principle, leave aside my primary submission, which is zero, sorry, leave aside my secondary submission, which is zero as the amount. This doesn't apply at all. What are we doing here? We're wasting this court's time with a non-issue. 169.4 does not apply on the clear wording of the Act. So we submit that this application, so-called, whatever it is, for security for, it's not even an application, I'm not even sure what it is. It's a distracting nonsense. It doesn't apply, it shouldn't be here. Your ladyships and your lordship have been burdened with an unnecessary argument, and we ask that the security forecast issue be struck from the roll if it's even on the roll. 169.4b has no application. May I just take an instruction? I'm told that, and I do apologize for using the word nonsense. Thank you, I do apologize. I always thought of, I have teenage kids and they tell me I'm talking nonsense. So I do apologize. It's not court manner, but I do apologize.
Word in the dictionary, but not necessarily in the current setting.
As it pleases the court. I do apologize.
Thank you.
Not accepted.
Thank you.
I do
Mr.
apologize. Anyway, the point is simply this. As a matter of legal principle, 169.4 has no application to the extent on the presumption that in this case, on these facts. And in the alternative, were the court to come to the conclusion that I'm wrong on that, then we go to 171 and the idea of security as a whole. And we say that this case is not a frivolous and vexatious case, and you make an award of security of 0. Were the court to reject both those submissions, and you come to the conclusion that I'm making submissions which don't have merit, then we say, order 100,000 rand for each. Those are my instructions. Although my legal submissions are, that isn't something that the court should. For each of the three, so 300 total. And even that we submit is, well, I would submit. That could be a bar to access to this court in certain circumstances. But nevertheless, those are my instructions. I can't get away from my instructions on that. Those are my instructions. But my legal submissions, 169.4 doesn't apply to the three opposing respondents, And 2, if it does apply, we come home on 0 because of 171, as it pleases the court.
Questions? Proceed.
Thank you.
Thank you, Mr. Katz.
May it please you, my lady, to request, we submit with respect that an amount of 1.8 million in security for cost is exorbitant, and as Justice Sibeya correctly pointed out, will constitute a bar to access of justice.
Mr. Carter, which hat are you now wearing?
The
in
second applicant.
Making your submissions.
I'm making it on the assumption that subject to joining, because if our application to join is successful, we will be liable for security. We will be similarly liable for security. And I want to distinguish our liability for security in terms of section 169 4B in respect to the ECN only, because unlike the IPC, the LPM's remedy relates to questioning the returns. We make common cause with the argument on the law with respect to the fact that SWAPO and the president are not entitled to security. We concede on our remedy that ECN will be entitled to security from us, from the LPM. We say, however, the amount of security, if the court is even so inclined to grant it to SWAPO once we join, and to the president, and to ECN, should be 50,000 each. We say so because the 500,000, because on the 17th of December last year, the government attorney demanded security for cost for 50,000. How that amount for 50,000, how that amount increases to 500,000 today.
That amount was demanded on whose behalf?
Yeah.
In respect of which party?
In respect of the president,
First respondent.
the first respondent. Yes, it was demanded on behalf of the president from the IPC. 50,000 was demanded as security. Here is a letter, and the letter was signed by the acting government attorney, Ms.
And it's in respect of this current matter, not on the one that served before the electoral court in December.
No, it's in respect of this matter, my lady. Because that matter had already been heard and disposed of. So for those reasons, we submit that is only fair, as it pleases the court.
Open it again.
Just a question, Mr. Carter. I did understand you correctly. Your word choice was when we are joined.
Yes. because it's subject to us being
Subject to
joined.
the joinder
Because
application.
we are only liable to pay security once
Yes,
we are joined. Otherwise, we
just want that
currently
to
we
be
are not.
clear.
Yes, as a place is God.
Thank you. Mr. Heathcote, reply?
My lady, I thought that this would, and my lord, I thought this would be a civilized start, but I see the gloves are off. I have the letter in front of me, which Mr. Kauta refers to. Unless I suffer from some eye illness, mine reads 500,000. I can show it to your ladyships.
Can you maybe just show it to Mr. Kauta first? Just
Yes.
so that
Seems there's fake news again.
Maybe you can look at Mr. Kauta's
Yeah.
Yes,
letter as
yes.
well.
Mr. Kauta, do you by any chance have the hard copy of that specific document? Because as far as I can recall, we did not receive that. We do not have a copy of that document.
We will hand it up, my lady.
It wasn't addressed even to Mr. Kauta. We never debated the discussion with him. What happened was that I did the draft. It was 500,000. The attorney entered 50. We immediately rectified it onto 500,000. It wasn't addressed to them.
So it's not necessarily fake news. It might be a typing error.
Well, it's fake news after the event.
You may reply, please.
My lady, with due respect, we made it correct, and that is also accepted by the other side. They don't even rely on that 50,000. May I just say this, and I'm not going to answer because I don't think it is necessary with respect to the submission made and then the suggestion made first by the IPC and then followed. Perhaps I should rephrase it in more civilized Latin terms, but to me it is sense non est. Thank you.
Thank you. Mr. Nari.
Lady, my ladyship, my lordship, we are happy to hear from the representative of the first, from the applicant, that a substantial portion of their case has fallen away. They are not challenging a return. Perhaps may I ask the court to have regard to prayer 4 of the notice of motion?
I certainly, and I don't want to give an explanation, but I've certainly never abandoned anything on behalf of the IPC. And prayer 4, I can give an explanation, but I don't think it's necessary. But the primary relief, which I will argue at the appropriate time, is that prayer 4 is dependent upon the true challenge, which is the review of the 28th of November. So when we said I've abandoned the challenge to the return, it's not true. We haven't abandoned it.
Yes.
But that's not our primary relief.
Mr. Nari.
May I make my submissions?
Yes, please.
I would ask the court to turn to prayer 4 of the notice of motion. It says, declaring the conduct of the election for members of the National Assembly in breach of the principles of Part 5 of the Electoral Act 2014, Act 5 of 2014, including its return and outcome, and setting same aside as unlawful and invalid. Now, when we received the applicant's papers, we from the reading of the founding affidavit and the notice of motion, we formed the view that this prayer was partially predicated on the now infamous Annexure E to the founding affidavit. We spent substantial time in answering to Annexure E to the founding affidavit. That annexure pertains to a purported report by a certain Ms. Auhamus, the alleged Secretary General of the IPC. And we raised therein, in answer to this prayer for the return to be set aside, spent substantial time answering thereto, producing an affidavit of certain Ms. Zenia, the Director of Operations of the Commission, but also indicated in the answering affidavit that the allegations contained in the report and confirmed under oath by Ms. Alphamus were false. False in the sense that she never inspected the material of the Electoral Commission on the dates of 18 and 19 December 2024 after access was granted by the court. And we said that this aspect of the founding papers renders them frivolous and vexatious because it was predicated on an untruth. Now my learned friend stands up and submits that there will be no order as to cost, but yet abandons a substantial part of the founding papers. No, but he says his case is predicated only on the extension, on the legality point. That is what I understood him to be saying. So, not so much the so-called irregularities.
But you heard what he said now.
Yes.
When you were on your feet, you heard how he clarified the position.
Yeah, but does it follow, Your Lordship? My submission is there is a substantial portion of the applicant's case that has fallen by the wayside. Your Lordship can have regard also to the heads of argument that was filed, but it was answered too. And that there was effort in answering that case, and we shall have to argue the cost in regard to those aspects of the case. So it is not a given that there shall be no order as to cost. There are specific allegations raised in respect of that aspect of the case, and we say that it's frivolous and it's vexatious, it is predicated on an untruth. And we have also filed a notice to strike out that part of the affidavit and the allegations. So we submit that there is a case to be made for security, if not for the balance of the affidavit, on that aspect of the founding affidavit of the applicant. We submit that there is a return on my learned friend for the first respondent recanting on his earlier submission that he's not challenging a return. Now we know the applicant, now we know they are challenging a return of the commission. So his initial submission also falls by the wayside. We know the commission's return is being challenged, and therefore security, they are liable to provide that security for cost. And it cannot be a zero amount, the leadership. It must give effect to the meaning and content of the legislation, and it must be the cost, potential cost of opposition of this application. We submit also that the court is not in a sense, required.
Your voice, please.
We also submit that the court is not required to make a prediction. That is not what the section says. It simply says that an applicant, that's 169 sub 4, an applicant must, at the time of presentation of an application before the electoral court, furnish security for the payment of all costs, charges, and expenses that may become payable by the applicant before the electoral court, in our case, to the person, or in the case of an election on party list, the political party or organization whose election or return is complained of. Certainly, they are complaining about a return of the Electoral Commission. They want the election set aside, and security must be provided for that. Yes, Your Lordship, my ladies, as far as the security to be provided is concerned, we stand by our earlier submission that it should be 750,000 Namibian dollars. The IPC is a political party. It has got substantial following. $750,000 should not be having the effect of it closing its doors. Otherwise,
But we don't know that.
yes, yes, but yes, we don't know that.
Yes.
So, but Your Lordship, my submission will be: security must be effective. Security.
Thank you, Mr. Mari.
What please?
Mr. Namanje?
Briefly, my ladies, Your Lordship, first, when I made submissions at the beginning, I assumed, only to realize that was incorrect, that nobody is contending that SWAPO is not entitled to, SWAPO is entitled to cost. I heard, if I followed very well, that a suggestion that SWAPO is not entitled because it's there is no challenge to the return or the outcome of an election. May I just make one submission there? The section is very clear. That is section 169, subsection 4. It's very clear. The legislature did not use simply cost. It said all cost. So in other words, when the court is making an assessment, it must, on a reasonable basis, seek to ensure that, although it will be difficult to come out exactly that all costs are covered, the court must assess the question of cost with a view to determining an amount that will be able to cover SWAPO's all costs. That's what the section is saying. The section may be unjust, but that is not the function of the court for now. That is a debate where IPC can send those who are able to move amendments and amend the act. And it's very clear, it says that in respect of an election on a party list, a political party involved, and that is SWAPO Party of Namibia. Now, I refer the court to page 18, paragraph 42, and paragraph 45 at page 19, where specifically the National General Secretary, who has since considered that what she told people under oath that she was at the inspection, she was not there, actually. She clearly and expressly pleaded that the returns, which include a certification of my clients' numbers, massive numbers ahead of IPC in terms of section 1082 of the Act. And lastly, so there's no question we are entitled to cost. Your Lordship. So, and lastly is the question of Justice Prinsloo, chairperson of the court. You remember that in the matter of SME Bank versus Bank of Namibia, you dealt with the question, or more or less the same section, which require presentation of security at the presentation of the application. That is actually at the time of issuance. But of course, correctly you found that in that matter, there was substantial compliance. In this matter, we asked that if the court were to determine an amount, we are going to contend in respect of the mooted stay that the matter cannot be stayed. Any court order with respect that is going to be made, it must be an order to the effect that security must be paid today within 24 hours, because, Your Lordship, we can have a litigant avoiding the effect of the provisions of the Act by trying to have the court somehow, in a way, assisting it, because we would have been entitled to ask, but did you pay security at the presentation? So we ask that any cost order that is going to be made, there is a directive that is paid within 24 hours. That is particularly so. We will be asking the court not to stay the matter and proceed into the merit. Those are my submissions.
The issue of the stay will be addressed
upon that's what I'm giving an indication to court that when that comes, we will be asking that the matter must not be stayed, as the court pleases.
Thank you. Mr. Narib, you had your opportunity.
Yes, just one matter, Your Ladyship. It's perhaps for the court to consider on my learned friend for the second applicant who is knocking on the door's application. The very application would certainly require security. The application to be joined is perhaps should be under the provisions of the rules of this court, and as such, should it not require security, it's better for the court to consider. We submit that if for that application to be disposed of, it may well require security.
Yes. That is exactly why the court asked Mr. Kauta about his use of the words once the application is considered. So,
as you please,
yes.
the court. Yes.
Counsel, thank you very much for your arguments in this regard. At this stage, the court will then adjourn to consider your submissions made regarding the issue of security. We will reconvene at 11:30. It is now 4 minutes to 11. We are adjourned.
Right. We listen, we don't judge.
Resume after the brief adjournment. The Electoral Court has considered the submissions made by the respective parties in this matter, and the ruling of this court is as follows. Brief reasons will be that having considered the submissions of the applicant's legal counsel in this regard, that zero amount for security should be set is unacceptable to this court. Section 169 sub 5b provides that security must be furnished in a monetary form. Zero, in this court's view, is not a monetary form. Mr. Diedrichs, thank you. You may be seated for this. Section 169 sub 4 provides in no uncertain terms that security must be paid at the time of presentation. Ergo, the applicant must pay security. There was submissions made regarding the frivolous aspect of the opposition in this matter. In terms of Section 171, this court cannot make the finding that the applicant seeks that the opposition in this matter is frivolous. Costs may or may not be incurred. Whether the opposition is frivolous is contentious at this point in time, which is an issue that must be for the consideration of this court, having heard the merits of the application. This court cannot be seen to prejudge the main application at this point in time. Any respondent that has been cited in this matter and that has the right to oppose, and if such a party oppose, it will incur costs and therefore is entitled to security. Having considered further the submissions by the parties on the specific amount, this court then determines that security for the payment of all costs, charges and expenses that may become payable by the applicant before this electoral court is set as follows. 150,000 is set in respect of the first respondent. 150,000 Namibian dollars is set in respect of the second and the third respondent, and 150,000 in respect of the fifth respondent, which then totals to amount of 450,000 Namibian dollars, and this amount is then hereby set in terms of Section 169. Now, just for the further information of the parties, this security is set in respect of IPC only. As there is currently still an application for joinder before this court, which will be determined in due course. Now, having said that, Council, and having also heard what Mr. Namanje said, it is the view of this court that this court has inherent powers to regulate its own proceedings in terms of inter alia Section 167(2), read with Rule 9 of the Rules of the Electoral Court. And the court has decided that we will proceed to hear arguments on when the security must be presented or filed. In addition thereto, given that the Supreme Court will on the 10th of February 2025 hear and determine the application involving the same challenge based on the same facts and similar relief, we will then now invite the parties to address this court on the point of whether the current application should be stayed pending the outcome of the application pending before the Supreme Court. So what the parties are then now requested to do is to firstly to make their submissions on the date for the filing of security, and secondly the issue of the stay.
Please, Your Majesty.
As the court.
On the two issues, the one is when my client must furnish the security. My instructions are to ask the court to make that order effective a week from today. As to the second issue, I understand that there will be an argument from the opposing respondents that they wish to go first. Our submission is that we are the applicants. It's our application that is before the court, and to the extent that there's any suggestion that our application shouldn't proceed, it's for us to deal with that up front. So we suggest and make the submission that's appropriate that we go first on the question of the stay. It's our application, applicants go first, I want to go first, as it pleases the court.
My lady, to say at this stage of the proceedings that the security must be given in a week is a bit presumptuous. That assumes that there will be a stay.
That is why the court asked that the issue is addressed, and then once the court has heard the argument on both these points, obviously the court will make a decision. If it is stayed, then the court will give directions. If it's not, then there are other issues to be considered in terms of Section 169.
Yes, then just on the ruling on who must begin.
I think just before you proceed, it may be the applicant's presumptuous, but that is their case, and then we need to hear what your case is.
Yes. My lord, the issue of who must start, I didn't say we must start. I wanted to say to your ladyship and your lordship that I am not sure who must start, because there is no application. Because we certainly accept no owners. They must start.
Yes. Well, this was a direction of this court that was provided to the parties yesterday. So, we have an agreement? Applicant start? Judge Chase? It is the decision of the court that the applicant starts.
So thank you. So am I invited to only address the court on the issue as to whether there should be a stay at this stage?
Well, you have already made your submission regarding the filing of the security.
And that would apply whatever the court decides on the stay. So if the court decides to grant or not to grant the stay, our submissions or our offer in respect of the security for costs is not going to change.
Then you may proceed with the stay.
My ladies, my lord, we were invited to orally address the court on the question of whether there should be a stay pending the finalization of the Supreme Court decision on the validity of the presidential election before we received yesterday afternoon the directive from the Supreme Court to the effect that the Supreme Court matter is to go ahead on the 10th of February 2025. And we would submit that whether or not the Supreme Court matter is scheduled to go ahead on the 10th of February 2025, this court should stay today's proceedings in any event as a matter of principle, legal principle. But now that we know, and the court knows, that the Supreme Court case would go ahead on the 10th of February 2025, a fortiori, the matter should be stayed. And we considered the invitation quite carefully, and we took the liberty, which we hope will assist the court, of reducing our oral submissions to writing, which I understand was presented and provided to the court this morning before the hearing. And we stand by those submissions. But perhaps I should just highlight the two aspects of those submissions. The first is, does this court have the power to stay proceedings? And this court, in its judgment on the security for costs aspect, highlighted that this court does have that power, well, highlighted this court's power to regulate its own process by virtue of the rules, and in particular a judgment which we highlight, which refers to Article 78(4) of the Constitution, and that's in paragraph 6 of our note. I'm not sure if the court's had an opportunity to read the note, so I don't need to. I'll just highlight some of the aspects. So in paragraph 6, it is suggested and said that this court has an inherent power to regulate its own process. And we would submit that that includes, and must include by definition, the inherent power to grant an order that is just and equitable. And we go further and refer to a judgment of the High Court in Prosecutor General versus Miguel, a 2017 case where that point is made. And we suggest that on the facts and circumstances of this case, it would be appropriate to grant a stay, and in particular, a stay pending the finalization of the Supreme Court case judgment. I do want to qualify that, or not qualify that, but I just want to present some sort of nuances to the question of finalization when. Because we've seen some suggestion from the respondents that to the extent that there is a stay, if I understand their submissions appropriately, some of the respondents, it should be a stay, but together with a status hearing or postponement of a status hearing in this court on the 11th of February. I don't know if this court has seen that. And our submissions are that the way the court framed the directive to us yesterday is perhaps the best way to do it, because we've considered all the different angles, such as a status hearing post 24 February 2025, because we know 24 February 2025, by virtue of the Act, is a date upon which the judgment of the Supreme Court will be delivered. So a status hearing on the 11th of February, we don't believe will go anywhere, because we don't know what will happen on the 10th of February. The court could, notionally, conceivably, order that the hearing on the merits of this case be determined or be set down for hearing, let's say at some date after the 24th of Feb, because by then we will know what the Supreme Court has decided. It's a notional possibility. There are certain difficulties to all of these possibilities, and that is that we don't know how the parties will respond in this court to whatever the Supreme Court decides, and the reasons for the Supreme Court decision. So the Supreme Court might uphold the application in part or in whole. It might have something to say about the LPM's involvement. We don't know what remedy. The LPM asked for different relief. So there's a whole range of possibilities that can arise from the Supreme Court judgment, which the parties we would submit need to respond to before this court hearing, whether it be by way of further affidavits, further written submissions, and a whole range of possibilities, which are very difficult to predict, if not impossible to predict, at this stage. So then I turn to, so that's my point about the question of tweaking the directive that was sent to the court by saying finalization pending the hearing of and judgment of the Supreme Court. So we would submit the way the court framed the directive is the appropriate order that should be granted. What is the test for a stay? We set it out in paragraphs 9 and following of our note, and we explain that, if the court's read it, don't need to rehearse that or restate it. I understand that our learned friends received the note at the same time that the court received the note. But simply put, what would the point be of this court going into what we would submit as the key factor was the presidential extension proclamation, Proclamation 34, valid or not, when that's going to be a central feature of the Supreme Court case? And we would submit that there's absolutely no point in that happening. And it wouldn't be just and equitable for this court to, for example, and it's a very interesting and difficult situation, for this court to make a finding that proclamation was invalid. And this court would have to do that within 48 hours of the hearing. So let's assume, just logically, this court hears us today, and on Friday, which is the 48-hour mark, or Monday, I'm not sure when the 48 hours concludes, it finds that the proclamation was good or bad. That same argument will be heard on the 10th of February. And how does one think about it logically, that if, for argument's sake, this court finds that the proclamation was invalid, it's a, and I use this word carefully, it would be an order in rem, because it's not a review of a decision, it's a setting aside of a presidential proclamation which has effect for the whole country and for all time. It's not a question of res judicata or any of those types of things. It's a judgment in rem. It's like setting aside a law and has effect as of the day of this court's judgment. Now we come to the Supreme Court. It could be argued the matter's moot because the proclamation's already set aside if the other side don't appeal. What is the status of this court's order? It would be somehow in a black hole legally were the court to set it aside. Similarly, if the court upholds it, maybe my client would wish to appeal that, but then again, we come to the Supreme Court, which would be hearing the challenge to the proclamation as a court of first and last instance, knowing that there's a judgment from the Electoral Court from a couple of weeks before which uphold the proclamation. That's also undesirable on a range of levels. So we would submit that from a just and equitable point of view and from a logical point of view, it wouldn't make sense, and I'm sorry I used that word, it would be not just and equitable for this court to continue to hear the matter when that issue is central to the case. I have to accept, which I do, the question of the validity of the 28th of November 2024 proclamation isn't the only issue that's before this court, and it's not the only issue that's before the Supreme Court. There are issues such as the consequential relief, such as the question that my learned friend for the Commission raised this morning, that will come into play depending on what the court says about the validity of the proclamation. So the question then arises like this: is it just and equitable to hear today's case, knowing that although the key issue is the validity of the proclamation, there are other ancillary issues which may be different, and we submit not. And we would also submit that for this court to properly consider the ancillary issues, the consequential issues, it would need to know as a final, on the basis of a final determination, the validity of the proclamation. So let's, for example, say, and let's just think it through, this court finds the proclamation was valid and dismisses the application. As an example, the Supreme Court finds that the proclamation was invalid. Then what happens to the consequential relief that should flow in this court from the invalidity of the proclamation? It would have never been argued, and this court wouldn't have had an opportunity to hear it, and we'd have to come back here to argue consequential relief in this court, bearing in mind what the Supreme Court found as to the proclamation, as the validity of the proclamation, having found not that this court was wrong, because there might not necessarily be an appeal, but this court's decision on it is different to that which the Supreme Court found. So those are all the reasons why we've set that out. We've tried to summarize it, why we would submit that justice and equity demand that this case be stayed, and stayed when pending the finalization of the Supreme Court judgment. And we submit that any suggestion of a status determination hearing, to the extent that there is to be one, should be set down for after the 24th of February rather than the 11th of February. And I've just summary, we don't believe that it's appropriate to set this matter down for a date until we know what the Supreme Court decision is, so that the parties can at least present to this court, whatever the case might be, proper argument on the consequences of the Supreme Court judgment for purposes of this application in this court, as it pleases the court.
Mr. Gutz. Mr. Heathcote.
Oh, sorry.
Mr.
Thank you, Mami.
Kauto.
I also won't be long, and I'm making submissions because unlike the IPC, I differ with respect to the status hearing of the 11th. And I just want to add one point. I make common cause with your legal submissions. I just want to add why this court has jurisdiction. And that jurisdiction, I want to refer to, may I refer the court to Rule 24 of the rules of this honorable court,
Electrical.
the electoral court rules.
Thank you.
That rule make provision, sub-rule 1, that subject to the Act, where these rules do not make provision for the procedure to be followed in any matter before the court, the rules of the High Court do apply to proceedings before the court with such qualifications, modifications, and adaptations as the court may consider appropriate. 2, the judicial case management rules in terms of the rules of the High Court apply to proceedings before the court with such qualifications, modifications, and adaptations as the managing judge may consider appropriate. 3, the practice directions issued in terms of the rules of the High Court apply to proceedings before the court with such qualifications, modifications, and adaptations as the court may consider appropriate. We submit that Rule 1, Sub-Rule 3 of the High Court has application, gives the court jurisdiction, because that rule deals with the overall overriding objectives of these rules is to facilitate the resolution of the real issues in dispute justly and speedily, efficiently, and cost effectively as far as practicable by, and we rely specifically on sub D, ensuring that cases are dealt with expeditiously and fairly. E, recognizing that judicial time and resources are limited, and therefore allotting each cause an appropriate share of the court's time and resources, while at the same time taking into account the need to allot resources to other causes. And F, considering the public interest in limiting issues in dispute and in early settlement of disputes by agreement between the parties in dispute. We submit that rule does 2 things. It first gives jurisdiction to the court, and secondly, we also submit Rule 1, 3, D, E, and F constitute obvious reasons why this court should stay, because any High Court, any Supreme Court decision surely will limit issues to be addressed before this court. And secondly, we ask that the matter be referred to a status hearing on the 11th of February, specifically for the LPM to move an application to be joined. That issue, that the issue of the LPM joining as a second applicant be dealt with at that hearing, as it pleases the court.
May I just ask a question? You make a submission that we should stay the matter pending the decision of the Supreme Court. At the same time, you want to move a joinder application in a matter that you submit should be stayed a day after the hearing in the Supreme Court. Can you please address the court on how that...
No, I did not make common cause with the hearing of the matter. I'm saying that of course, the merits of the matter can be heard on after the Supreme Court has determined. But I am moving that in the meantime, the limited issue of joinder be dealt with before. Why? Because it will sort out the issue of security, because the issue of security of the LPM has not been determined, and it can't be determined even if we are successful in a joinder application. If it only takes place after the Supreme Court judgment, it will give the court and the parties and no opportunity to the LPM to pay any security, because the matter will have been dealt with on the merits at all. If joinder and the merits are dealt with on the same day, there will be no opportunity to deal with the payment of security.
Thank you.
And as a president.
Mr. Yusko.
My ladies and my lord, I will return to the owners because it is a major concern with respect. But let me read to you what I had a vision last night, and we will certainly argue this in the Supreme Court. Let me read to you a notional judgment from the Supreme Court. Says the court, it is not necessary to decide any issue raised other than one. We shall assume, without deciding, that a mistake occurred as envisaged in Chapter 5. We move straight on for determination to Section 115, dealing with materiality. It is quite plain that the application cannot succeed because there is no materiality issue proven. We know that on the extended days, 11,000 people voted. Mr. Itula lost with 350,000 votes. Mr. Swartboy surpassed him to 589,000 votes. He lost. No one but no one can show materiality. The application is dismissed. So we come to this quote on that news. What convenience did we reach? Let me put this in perspective, my ladies and my lord. The Independent Patriots for Change comes to this court and they say they want to set aside the entire election. But we know for a fact, and I refer you to page 119, paragraph 120 of the record, page 190, paragraph 20. There it is made plain by the Commission in its answering affidavit.
Yes, Mr. Yusko, just to catch up with you.
Sorry, my lady.
Paragraph?
120, it's at the foot of the page. It says the above table demonstrates that SWAPO will gain one seat.
Not with you. Not with you.
190.
Yes, we are on page 190.
In mine, it's 120, paragraph 120.
The page 190 in the court's bundle only have paragraph 80, 81, 82, 83.
Oh, my lady, that's
Page 207.
207, thank you. I will just then refer to the numbering. That must then also be sorted out. I'm indebted to you. Well, there the Commission says, in short, you can just read it, but as a result of the 2 days extension, the IPC gained a seat, won a seat. SWAPO lost a seat. So you come to court to set aside your winnings. And then when the court asks, should there be a stay, then I would also ask for a stay, as they do, because it doesn't make sense at all. But let me say to you a further issue, if your ladyships and your lordship will turn to page, well, that is now in my document, page 320, but it is the speech that was made by Agwamus on radio station or TV station, I'm not sure, it is annexure. I'm now a bit off track because mine says page 320. And if it is, huh? ECN 20, annexure ECN 20.
Page 335
Yes, thank you, my
in
lady.
our bundles.
Yes. And then if you turn to that, on top of that document, there's a written number. Can I refer to that? It's page 3 on top in mine. The sort of typist number 3. In the middle of the page, this is what we were promised. This is before we started to even get off the mark. This is what was promised to this court and at least to the entire nation. This is the person speaking. We've got so many irregularities, and we're getting hundreds and hundreds of reports and affidavits and statements under oath from members of the public who are also supporting the findings that we have been receiving from our representatives at various polling stations across the country. Your ladyships turn the pages to number 5, same numbering, which I refer to, growing in confidence, about 5 lines from the top. If you got 100,000 Namibians who have been denied their right to vote, even though they were in queues on polling day, if we were to rely on the currency per seat in the National Assembly for 19 and 20, a bit down, if 100,000 Namibians were denied their right to vote, which is what we are aiming for, and which is what we are gathering very fast approaching that number. We were threatened and the nation was told they will come up with 100,000 affidavits. We have scrutinized this application. The total number of affidavit is 0. Let me move on to the landless people movement. They are indeed running with the hares and hunting with the hounds. They do not know what to move. Is it to move an application, a counter application, or a joinder application? They are just not moving anywhere, the landless people movement with respect. My ladies and my lord, they have, I've shown you what Mr. Swatboy lost in the presidential stuff, but what is it? When they bring an urgent application, I'm not sure as respondent or applicant, and then suddenly when the day of reckoning comes, they embrace a stay. If I move an urgent application in any court, and I come to your ladyship and your lordship, and I say, please decide urgency for me up front, and you say, yes, it's urgent, then I get up and say, can I have a stay, please? With due respect, can we just get some principle in the movement of the landless people movement? So, let me come then, my ladies and my lords, to the notice which you have sent yesterday. And let me immediately say this. When I got the notice, it was together with 100 pages heads at lunch from the landless people movement, and also a replying affidavit from them at 12 o'clock the previous evening. And I thought, actually, and I must be honest, my first thought was, oh, thank you. We're going to put order in this. Just stay this thing. And it may be convenient. Those were my first thoughts. But, my lady, on second consideration and on deeper reflection, I realized that it's not possible. Why do we say and submit that it's not possible? We say so on a legal basis and a factual basis. Let me start off with the facts. or the factual basis. First of all, my lady, who carries the onus in this application? Can I immediately refer you to the case of what our learned friends also refer to, the Olivier case? And I will beg to hand up to your lordship and your ladyship copies. You will see that Mr. Justice Frank deals with the power of stay in that judgment really from paragraph 22 and further. You will further note, my lord and my ladies, that he deals with two different kinds of stay, a permanent stay and a temporary stay, which he reckons, or with reference to authority, says a temporary stay is similar to a postponement. Moving back, you bring an urgent application and then you move a postponement. Now, my lady and my lord, can I ask you to turn? You will read those other paragraphs, but may I respectfully refer to paragraph 33. The Supreme Court says, lastly, in respect of approaches to court to stay proceedings, either permanently or temporarily, it is important to restate that such relief must be sought by way of application, and that to raise it in a special plea is wholly irregular. The facts underpinning the relief and the grounds for the stay must appear from a substantive application to which the other party will be able to respond, so that the full picture is put before court for determination. There is no application. The court is, of course, entitled to ask the question, for sure. And let me immediately say, I accept that the High Court has a jurisdiction, inherent or otherwise, to stay proceedings pending certain things. What those things are is a difficult question. We know for a fact, and that is when I come to the law, that whatever inherent jurisdiction the High Court has, it does not operate on equity. That much we've heard too many times from the Supreme Court. In fact, this very judgment tells us that it's not an equity. Postponement is limited or sometimes a bit equitable. But coming back now to the facts, I know, if I may refer you to the note which the court issued. The court says that we must address why the application should not be stayed pending finalization of the challenge filed in the Supreme Court, given the similarity in the nature of the challenge and the relief sought in both courts and the facts cited in support thereof. Well, I assume you could take judicial notice of what is stated in the Supreme Court and that you have done so. But the problem we have, with due respect to the note, my ladies and my lord, is which similar fact? Exactly which similar fact? Because I don't know, and they have the onus, and it is against what the Supreme Court says that we must argue something which they will have the onus, and we cannot crystallize this similar fact. Yes, there are similar issues. But what are the similar facts? That is, to me, with respect, a major concern. But let us move on. What we know is that we cannot go to the Supreme Court with respect and hand up a little list and say to the Supreme Court, my lords, and if there are ladies, my ladies, will you please, for sake of completeness and transparency and speed, also determine these similar issues? Well, you can't do that in the Supreme Court, and the Supreme Court will say, who are you to come and tell me what I will determine the case? So there may be one issue, there may be 10 issues, or they may be, in my notional fictitious judgment which I delivered in the beginning, determined absolutely nothing. Now, what we also know now is that any issue which may be touched upon by the Supreme Court, we don't know whether it will be said to be the ratio decidendi or the obiter remark. We know if we come here, and we've had that debate previously where the court had to determine what is a ratio and not, and it is not an easy debate, not at all. So I can promise with respect, and I foresee, that whatever point is decided there, they will come and say, oh, that was just vaguely obiter. That is not based on the exact same facts. That may be persuasive, but it is not ratio decidendi. What then is it with respect that we assume in this question which your ladyships and your lordship has posed to us? We assume, because that would be helpful, we assume that there will be an issue be decided which is the ratio decidendi and which must be applied by this court. That is the basis of the assumption. And with respect, no case has been made out. It would be wonderful, with due respect, if we can assume that. I would be the first one if I can promise your ladyships that I go to the Supreme Court and come back and say, here's this solution, follow it. That's not going to happen with these people, and I'll come to it in a moment. Why do we say that? They will not go away. Not in the Supreme Court, not in the High Court. My ladies, they are on record. Come hell or high water, we will go to court. The biggest fear I have, and which I respectfully submit should be taken into consideration, is that terrible situation which a lawyer and a court finds it or him or herself in if you take a judgment from the Supreme Court and you start interpreting it like a piece of legislation to fit the argument in the High Court so that this court must now find in your favor. That is to be avoided at all costs. And if you cannot come to that conclusion that that is going to be avoided, then the onus is paramount. If they want to, and if they thought that a stay application must be brought, then they should have done so. There is absolutely nothing wrong if this court considered the issue and asked for argument on it, because it sounds fine. But the submission now is on the facts. It is not taking us anywhere. Let me turn to the law. Now, there is no doubt in our law that this court has an inherent jurisdiction. Let me assume, for purposes of this argument, that the High Court of Namibia, or this court, in general, have, if there is no provision in a rule for it, and as we call it, if there is a lacuna in the procedure, because that is when a High Court's jurisdiction kicks in the absence of a rule. You don't have inherent jurisdiction when there is a rule governing it. I suppose there are too many authorities on that for your ladyship or your lordship. If you want to, you can read Ausencare judgment of the High Court and the Supreme Court, and too many others. So, what we also know is the court does not have an inherent jurisdiction to do what the statute doesn't want. For sure. It's the same as acting against the prohibition. Now, what is it that this piece of legislation wants? Let's start from the beginning. It is so that when the legislator drafted or adopted this piece of legislation, they knew, all those who voted in favor of it, I suppose some of the IPC members now also, and also Mr. Swartboy, sometimes a bit vociferous, but he voted in its favor. Now let us look what it means. Surely the legislator knew that out of the same situation, the same election, where there is a presidential election and a general election, the same people standing in the same queue, the same complainants with the same gripes, the same disheartened disappointments, the same bitter disappointment to scream, we lost, but we shouldn't have. Out of that same facts will always come the same complaints. So how on earth could the legislator do and then create, out of those same circumstances, same facts, a situation where you go to the electoral court and one you go to the Supreme Court, because that is what the legislator wanted. And if, may I say this with respect, my ladies and my lord, if this matter is stayed, it is not what the legislator wants. Because what the legislator wants is fastness and finality. And I will turn to the legislation in a moment. The legislator, if we stay this, then the ratio decidendi, if I may use that phrase, which will be in the fly note, is this. In a general election where the president and the general election is held at the same time, as a general rule, the electoral court shall stay the proceedings if there is also a case pending in the Supreme Court. If you want to, you do like the legislator does and say, unless there's exceptional circumstances, and we start debate that. With due respect, let me refer your ladyships and your lordship to the provisions of the Act itself at section 170. It says, subject to subsection 2, the electoral court, sorry my lady, I apologize. Subject to subsection 2, the electoral court at a hearing must give a written or oral decision and reasons for the decision at the conclusion of the hearing, or as soon as possible after the conclusion of the hearing, having due regard to the complexity of the matter. The electoral court is not given a stay power. It must conclusively determine and quickly determine all post-election matters 7 days before the swearing in of the office bearer concerned. We know when that more or less happens, by 21 March or so forth. Subject to subsection 2, if the electoral court presides over a hearing seeking urgent relief, our landless people movement, which must be heard on an urgent basis, it must give a written or oral decision and reasons for the decision at the conclusion of the hearing, or as soon as possible after, having regard to the complexity, but not later than 72 hours from the hearing. That's a tall order. That is what the legislator wants. Because when the legislator runs or writes or adopts this piece of legislation, it for sure knows, with respect, that the same issues will arise out of the same facts, and it does not give you a power to stay, let alone in the rules is application made for a provision made for an application for stay. Now, let us just take
Having regard to the Electoral Act, under no circumstances can the Electoral Court stay the proceedings.
not inherently, no, because it's a prohibition, in essence. It is against what the legislator wants. And if the legislator wants it, then you will not have it. I go further, my lord, in these circumstances, it would be not correct for the court to stay it mero moto. So there are two issues. It's first of all inherent jurisdiction that we know the High Court has, unless the drive of the legislation points towards a different direction. And then the next issue is, can the court raise it mero moto? Because when the court raises it mero moto, we are left in the dark, and I say this with due respect, onto which facts your ladyships and your lordship has in mind which are similar. I'm arguing here not knowing what those similar facts are. I can guess, but that is not how legislation works. So some conclusion is also that the Electoral Act knows that after you give your judgment, there will be an appeal, or may be an appeal. And all these things, notionally, must still happen this year. Before 21 March, we will be falling over our feet to now wait for the Supreme Court judgment and then come back here, sort security out. The landless people, they move, then they're on the applicant side, then they're on the respondent side. They actually bring, listen to this, with due respect, the landless people brings a counter application against the IPC. What claim do they have against the IPC? An exigible claim. You must have a claim which you can enforce against the applicant if you bring a counter application. They are not moving anywhere. They refer to a counter application as well in their papers.
But there isn't a counter application
Yes,
before court.
but look at the headings of the affidavits, my lady.
But I think for the purpose of this exercise, we are dealing with the IPC matter.
Yes.
Yes.
So, but for a convenience side, what will happen with this joinder? It's just they've been annoying me all along. They just follow their own rules, this landless people movement. They file midnight at 12 and then 12 o'clock in the afternoon before I must go to court the next day. But those are all now difficulties in this decision-making process. So, to conclude then on the law, it is simply this. The Act does not envisage a stay, because if it is to be stayed, then it will always be stayed, because I cannot think of, out of the same election, different facts in the Supreme Court and different facts. And there are many other issues, and I've given you that notionally, and I will be asking in the Supreme Court, which I cannot do here. I will say, my lords, let's assume everything, and let's look at section 150. The losses are just too high to make a difference.
Mr. Heathcote, is it so that the main relief sought in the Supreme Court and the main relief sought in this court is a setting aside of the proclamation?
No, ma'am.
That's not so.
That's not true. In fact, your ladyship, if you have regard again to the papers filed in the Supreme Court, in this court, the president, and I'm speaking now for my side, in this court, that document is sought to be set aside. There in paragraph 4, last, they just made it in, sort of as an afterthought. The IPC in the Supreme Court does not ask to set aside anything. In the Supreme Court, they simply ask for declarators. And we take fair and square the Oudekral point in the Supreme Court, which I say we cannot take here. And if, for instance, in the Supreme Court, the Oudekral, and you can look at Minister of Finance versus Duplessis, which the Supreme Court, is it Duplessis? Duplessis, which said that you cannot ask for a declarator only if you don't set it aside. So notionally, your ladyship's question points towards a different difficulty. They may be thrown out in the Supreme Court simply on Oudekral, and then it doesn't help at all. May I then end off? So let me conclude on the facts.
Isn't it that the opening prayers that IPC 6, both here and in the Supreme Court, is to declare Proclamation 34 of 2024 in violation of the Constitution and the Electoral Act?
They do, yes.
Yes.
But in the Supreme Court, they do not seek to set it aside. And we know what Oudekral says. In fact, we raise Oudekral. You will see in our heads of argument, we don't raise Oudekral because of that prayer 4, which I say will save them by the bell. But in the Supreme Court, the IPC doesn't ask for setting aside. They're going to lose also on Oudekral. They must lose on Oudekral because the authority is there, not from this court, from the Supreme Court. So, in conclusion then, this landless people movement and the IPC Patriots, they've told us they're not going anywhere. They said they will come and they will fight high or hell or high water. If you permit me to end off with a bit of rhetorical flourish, getting some inspiration from Churchill, can I hand this up to you? I see Mrs. Justice Chase is looking at me. You should be looking at me, I'm arguing on it. This is what these people will do. They will not go away. This is not going to help if it stays. They shall continue with this losing battle come hell or high water. They shall not raise the white flag in this court when, not if, they fail in the Supreme Court. They will continue to distort the truth on TikTok and Telegram. They will continue to defame the courts and tarnish Namibia's good name in the world on national and international airwaves. They shall continue with wanting and waning confidence in the Hameringhausen hills and while staring defeat in the face in the Namibian valleys. They shall continue to brutalize the truth on the beaches of Walvis Bay and Swakopmund. They shall continue with a false fact and fake news on Facebook. When the hour of reckoning comes to this court, they opportunistically embrace a possible stay to avoid political starvation. Please, Your Worship.
On the issue of the security and the payment.
My lady,
the payment.
Yes, if it is not stayed, then we have submitted that we should continue tomorrow to save costs. But they must then at least, whatever, if it is refused, the stay, or not granted rather, then there is no time period that must be given. Then they must give the security before we start. If we start tomorrow, which we submit should be, then they must give it before tomorrow. If it is stayed, then they must just give it before we start. So there is no need to pay, but they must give it before we get up and fight the battle.
Is this now on the beaches and on the shores?
On the beaches and on the shores. I come from Helmeringhausen. There is a hill.
Thank you.
Please, Your
Mr. Narib.
May it please you, my ladies, your lordship, for the most part, I make common cause with the submissions that were made by my learned friend on behalf of the first respondent. I just want to correct one particular aspect of his submissions. The import of it remains the same, but the orders that are sought in the Supreme Court and in the High Court were turned around. In the High Court, or in the Electoral Court here, they do not seek to set aside the proclamation. Rather, they seek only the declaratory orders. And in the Supreme Court, they indeed do seek to set them aside. So with that, the import of the submission remains the same. There is a slight difference in the relief that is sought on that score. If your lordships, you have your lordships and your lords, you have the notice of motion before you, you will see that there, in the first prayer, there will be no prayer for setting it aside. With that, I would submit. I make common cause with my learned friend for the first respondent. We also ask that should the stay not be granted, we proceed with the matter tomorrow. So court pleases.
Thank you.
to my colleague.
I start my argument, your ladies and your lordships, on a very important constitutional imperative. And that is, your lordship, under Article 12 of the Namibian Constitution, every citizen of this country is entitled to have rights and obligation in civil disputes adjudicated upon by an impartial and competent court. That's the first constitutional imperative. We must keep it at the back of our mind before even deciding on the question of stay. That's a constitutional right of every citizen of this country. And the judiciary, in the context of an election, a specialized body, as far as National Assembly is concerned, is nominated by the legislature for purposes of litigants, those who may be applicants, assert their rights, and place issues before a specialized electoral court, for that court to determine the party's rights, but most importantly, for me that is acting for SWAPO party, and of course it's a fact, its presidential candidate won these elections. We would want that dispute, and in fact the wool of Namibia, that certainty is being decided together with the rights and obligations of the private parties in a political context before this court. Now, when the court, somebody asks, are you staying? In certain instances, effectively and in substance, it may amount to a court within a context where it is required to immediately and with speed decide a dispute. In effect, it may amount to a court refusing to carry out a determination of rights and obligations of the party under Article 12, albeit shortly. The second principle, in effect, I'm very careful with the choice of words. Okay. In the context of an election dispute,
which on international standard, legal standard, and local legal standards, a dispute must be, an electoral dispute must be determined and adjudicated upon without any delay, particularly by the court or a tribunal which has been ordained statutorily by Parliament to adjudicate such dispute. So what we are saying is the parties are expecting an adjudication and determination of rights and duties. The court, as a third branch of the state, has been given both the statutory and constitutional duty and obligation to adjudicate. A state, albeit to delay, in effect in an electoral context, may amount to a denial because we are getting closer to the 21st of March. I will come back to that argument, Your Lordship. The second is really to say what is the nature of the dispute before court. It's not a private dispute. The decision to be made by this court or not to be made by this court is not only a concern of the IPC and the respondents in the application, is in fact a concern of everybody, Your Lordship. And to highlight that, I start by referring the court to our heads of arguments, that is SWAPO's heads of arguments, Your Lordship. And I invite the court to...
Referring to your main heads?
Yes, yes.
This is not supplementary heads dealing with the stay issue?
Yes, may. At paragraph 24, page 11 of our heads of arguments, my ladies and Your Lordship, we refer to an Indian case of the Supreme Court of India. And over the page, at page 12, Your Lordship, under paragraph, the second sentence, you would see that the Indian courts highlight and underscore the fact that an election is a public act. So it's not a private matter. It's a public act, and that it does not only affect one person or two, but it pertains to the collective will of the whole, in Indian case they refer to constituency, but here we are referring to the whole nation, Your Lordship. With that in mind, Your Lordship, I then address the question that, in fact, it will be an irregularity in the context for this court not to hear the matter on the merits, and I will justify why we are saying that. Now, we know that on the 30th of November 2024, IPC President, with audacity of courage and determination, told all and sundry that they have made an unshakable decision not to accept the outcome of election. That was before the announcement on the 3rd of December 2024. That unshakable, and that is a choice of the word by the author, is repeated by the National General Secretary of the same party in the interview with Newsroom Advocate Heathcote referred to. That is the background, that a pronouncement was even made prior to the announcement of the outcome of an election. So in other words, there is a hardened and unyielding position taken by a litigant in this court as far as their position and stance towards the outcome. Now, I have a bundle, Your Lordship, small bundle to hand up. And why I'm handing up the bundle, Your Lordship, first, is to talk about the duty, not the jurisdiction to stay. First, I want to address the duty of court. I start that, Your Lordship, by first referring to a judgment authored by Justice Sibea, and that is at page 2 of the bundle, that is Cheundo versus Government of the Republic of Namibia. And in the interest of time, my ladies and Your Lordship, I simply refer to the sentiments of Justice Sibea at page 10 of the bundle from that judgment. First, remember this matter was on the jurisdiction of the High Court as opposed to the Electoral Court. And then Justice Sibea deals with the purpose of the Act under paragraph 17, and then ends at page 12, paragraph 23, Your Lordship. And I refer to the second last sentences of paragraph 23 at page 11, and he says the following: I'm further of the view that embodied in the act, in the court is an envisaged, specialized, and I highlight the word specialized, court mandated to deal exclusively with electoral disputes. The respondent also expects its electoral issues to be adjudicated upon by a specially constituted panel of judges according to law and dedicated to hearing electoral dispute. And in this matter, my ladies and Your Lordship, it's a dispute pertaining to the National Assembly. In the wisdom of Parliament in 2014, Parliament decided by legislation that dispute pertaining to presidential elections will be dealt with by the Supreme Court as both the court of first instance and court of last instance. Parliament, in its wisdom, then said it appears on the jurisdiction, leaving out the National Assembly dispute, that goes to the specialized body. Now, as a matter of the separation of power between the judiciary and legislature, the judiciary cannot wish. It would have been better done or made by Parliament. It have to live with the scheme and structure as to how electoral disputes are adjudicated and decided in Namibia. And it's not for the court, for the court, after the judge president, who has the power to constitute an ad hoc court, it's a permanent court, but obviously it's the constitution of the bench is triggered by an application. And that application, formally and in substance, introduced a dispute for adjudication. Hence, it's not for after the bench has been constituted by the judge president to fold its hands and say, we wish, how can, if Parliament knew that in Namibia, because of our history, in 1990, Parliament's term is 5 years. Executive, obviously, is also 5 years. It was always going to be that the presidential election and National Assembly election will be held at the same time. That being the case, post-election disputes would almost arise from the same facts. And Parliament knew. Yet, it decided the Electoral Court must adjudicate other disputes while the Supreme Court deals with the presidential election disputes. With greatest respect, on a matter of separation of a principle of separation of power, the judiciary cannot think away that demarcation. That's one. So now on the duty, once a specialized court is created by statute, and can I just make this point, my ladies and Your Lordship? Last night, I had an opportunity to simply go through international instruments applicable to this matter, to this question. And some of them are all over, being SADC protocols and rules, and I think rules and guidelines pertaining to observation of election in SADC countries. Those principles to which Namibia is a party all have two key principles. The first one is that as far as the finalization of an election in any country, those who lost must have a soul, must have guts, and must have preparedness to accept the outcome. However, their right in case of them being not happy must be addressed and asserted in a special tribunal established by an act of parliament which is independent. First, once the outcome has been announced, SADC principle is that accept the outcome. If you are not happy, state must have established by law a special and independent specialized body. And the third and last principle is that there must be expeditious finalization, conclusion, and disposal of election disputes. These same principles, my ladies and your lordship, are also repeated in same instrument at the OAU level, and I invite the court, they are all there on the website, and Namibia is a party to all these principles. So it's not only a question of a domestic law requiring that a specialized court is duty bound to adjudicate and conclude electoral dispute, but also that it must do it as soon as it can and as required by law. Hence, your lordship, I refer the court to page 30 of the bundle. Your lordship, if the extracted page 30 is taken from the book, a cover page appearing at page 28 of the bundle, that is administrative law in South Africa. But the only reference I want to refer to is at page 30 of the bundle, where the author, and this, mind you, my ladies and your lordship, this is not in an election context. It is in civil, general civil context. But in the second paragraph it says, the use of time bar or time limitation clauses is supported by reasons of practical convenience, such as the need to establish the legality of action at the earliest possible stage and danger of losing evidence as time passes. The avoidance of inordinate delay promotes certainty as well as the timeous resolution of dispute and enhances the equality of adjudication. As Baxter notes, there is also an important interest in finality. Public authorities must be able to proceed with public works, which are often extremely expensive, without fearing that the entire basis of their action must be undermined by a successful attack on the legality of the undertaking, of course, at a later stage. That's one. We then, I refer my ladies and your lordship to page 21 of our heads of argument, 31 rather. There is a very important South African case on the issue raised by court, and that is the case of the Standard Bank and two others versus Pongo. May I just find out from court that whether at the top of page 31, the citation has been given in handwritten form, Your Lordship. If that is the case, I, with speed, Your Lordship, refer the court simply to a summary of that SCA judgment. And the summary is this. A court is obliged, and I highlight the word obliged, by law to hear any matter that falls within its jurisdiction and has no power to exercise a discretion to decline to hear such a matter on the ground that another court has concurrent jurisdiction. In this context, let's make it clear. The Supreme Court is not hearing a dispute pertaining to the National Assembly election because, first of all, it has no jurisdiction to do that as a court of first instance. So I'm not saying it's a concurrent, but in this context is, of course, the issue may partially be smear, but the issues, as I will demonstrate, are not even smear on the basis of the facts that are placed in front of court. I'm not talking about papers of the Supreme Court which are not before court. All I'm trying to say is that a court is not entitled to shy away. I use the word shy away deliberately because the court is required to be independent. And independent sometimes in a political polarized country like Namibia sometimes, people think about it when pressure is coming from the executive only and those who have made it a practice to insult all and sundry, including the judges. But sometimes is the judge not being independent because he or she fears what, even if there is no bar, legal bar to the hearing, what if I'm found to be wrong in a hearing somewhere else? It's an issue of independence. The court has no business whatsoever, with greatest respect, to fear and in fact speculate. What if we do this? Because you have only one business. The legislation says you must adjudicate. It must not concern you. You may be found to be correct or wrong on another day, and I will demonstrate why. Your Lordship, in the interest of time, I refer to 4 parts of the judgment that covers what I said at page 49.
Papers filed in the Supreme Court are not before this court.
Yes.
Is this court not entitled to take judicial notice of the court papers filed in the Supreme Court?
No. I'll come back to the issue of judicial notice.
Yes.
Not at all. In fact, it may even be an irregularity, and I will say why. But I'll come back to that. At page 49, Your Lordship, paragraph 27 of the judgment, it's simply that it is also law of long standing that when a high court has a matter before it that could have been brought in a magistrate court, it has no power to refuse to hear it. Remember then, the principles are that you can say it would have been more convenient and cost-wise to go to the magistrate. The remedy of the court is to say, I will punish you with cost and so forth. But refusing or staying while you institute in the magistrate court, except of course in arbitration, it would be wrong. Paragraph, Your Lordship, at page 50, paragraph 29, towards the end, that quotation towards the end from the case of Standard Bank versus Sheba, it's very important on the question. And then at page 51, both paragraph 30 and 31, Your Lordship, you can even see that in paragraph 31, the court referred to the question of agri-wire versus the Competition Commission of Competition Commission and so forth. Now, what am I driving to? The totality of the judgment, Your Lordship, you will consider. What am I driving to is this. The background, prior to 2014, Your Lordship, Your Ladyships, and Your Lordship,
Counsel, you will note it's past 1,
yes.
but if we can sit and finish and hear the arguments, is there any issue?
Then we prefer to continue until arguments is finished.
Yes, yes, I will move with speed.
Thank you.
And finalize my arguments now. What I was saying, my ladies, your lordship, is this. Prior to 2014, the 1992 Act was in force. Both presidential elections and National Assembly elections dispute, as a court of first instance, the High Court was bestowed with such power. It doesn't matter both. You got to start in the Supreme Court, and the only way you can go to the Supreme Court directly, unless a question is taken there by the Attorney General. Then comes the wholesale amendment by the 2014 Act, and it did a number of things. First of all, it did away with prescription. What happens if the court finds against the ECN? In other words, if the court avoid the election, what happens? Your ladyship, you can see in the LDP versus ECN, that is a judgment reported in 2013, volume 2. Volume 2, Justice Damaso Ben Parker set out the consequential remedy and relief the court on its own could make after declaring an election outcome as invalid. So that was prescribed in a statute. The 2014 Act did away with that. What the effect of that is for the applicant to plead its case, seek the relevant relief, and that relief must be effective. If it is presidential election, it is in the Supreme Court. If it is this kind of election, it will then be in this court. So you look at the relief and the jurisdiction the court have, your lordship. Now, one of the disputes being LDP versus ECN, another one, my ladies and your lordship, was LDP versus ECN 2010, volume 2, NR 487. The question arose in the Supreme Court about the former Rule 3 of the High Court, after finding that the High Court was wrong in respect of the application of that rule to the dispute. The question arose whether the Supreme Court should then dispose of the dispute in the Supreme Court. The reasoning of the Supreme Court runs from page 532 of the judgment to 533 and gave good reasons why the legislature in the repealed act have chosen the High Court to be the court of first instance. And one of the reasons the Supreme Court said is to benefit from the reasoning of the High Court. In this case, the 3 senior judges chosen by the judge president, of course, because of their experience and their skills. There is always a consideration of the Supreme Court benefiting from the reasoning of the lower court. So now, let me then conclude by demonstrating that what are we doing here, actually? The matter isn't in any way different on the basis of the fact that is before court. I caution ominously so that with respect, the court cannot rely on the facts not before it. This is because recently in South Africa, such a mistake occurred. In South Africa, I'm looking for my copies. May I ask the court to go to paragraph 35 without wasting time, with greatest respect. 32 rather, yes. The first sentence already tells you, it says, the admissibility of the criminal record was never revisited by the trial court after it has been admitted provisionally. So in other words, what happened in that trial, there was a record, including a testimony of a key witness. But that record was never handed up to court. Finally, it was simply provisionally handed up as an exhibit. The trial concluded without the court revisiting the provisional handing up of the record, and that witness was never called. The judge, in finding an accused guilty, amongst others, relied on that record because it included evidence of a witness, but that witness was not called for purposes of a trial and finding of guilty. The court found that it was an irregularity for a court to make a determination of rights and obligations based on evidence that is not properly before court. Your Lordship, the judgment is very clear. What am I saying in this respect? Of course, I'm not here to sweat around and explain to court from the bar what this...
Evidence in the criminal trial.
Yes, Your Lordship. But the point I am raising is on the method and the procedure adopted. It's an irregularity. I'm not talking about correctness. I'm saying the court, when I looked at the notice yesterday, it invited us to make submissions that the facts in the Supreme Court and in the High Court are similar. Remember that the court, it's not only the executive that is subject to the principle of...
Don't do that, sir. You're taking photographs, and you cannot do that, and it's very disturbing. My apologies, Mr. Namanje.
So what I'm saying, the notice, if I properly considered it, one of the matter where we're supposed to address court on the similarity of the facts were in this court and in the Supreme Court. That is what we were called upon to determine. Now, what I'm trying just is to answer Justice Sibea's question. My point, why I refer to the South African court, the court is also subject to the doctrine of accountability. When you write your judgment, you must account. If you were to find that the facts are similar, which facts were brought to whom and to you and by whom and when, Your Lordship? Is it the facts taken from newspapers, article? Is it on social media? What are those facts? It's true. There is a notice of motion in the Supreme Court produced in this court. Only the notice of motion, but that does not represent the totality of facts and issues raised in the Supreme Court. So in other words, it may be an irregularity because a judge, assuming there is an inquiry and a judge is asked to further provide reasons and say, the summary, what are the summary that you find that they are similar? In your judgment as a matter of law, you had to account those facts and what they are and where you found them. Surely, it can never be facts taken elsewhere other than in the proceedings you are hearing today, Your Lordship, my ladies. So I then conclude by showing the court that actually, in this matter is very different. May I invite the court to the IPC heads of argument. Page 26. Uh, 25, to start with, page 25. Just by way of the background, we decided not to be gentle towards IPC and to be hard in our heads of arguments to say, you told the world, being carefree as to what would happen to Namibia, telling people you will get 100,000 of affidavits. There is a multitude of dispute irregularities, including people voting while they are not on the voters' roll. We responded, we filed an affidavit by Karel Gaeb, my junior here, and demonstrated that this is not true. And then we get a replying affidavit which only deal with one single irregularity. And everything appeared to have disappeared, but today we appear to hear that those things are still alive issues. Fine. Now, if you look at C, at page 25, one of the points apparently that you must adjudicate is that the conduct of the National Assembly election was unconstitutional. I highlight unconstitutional because the extension did not apply across Namibia. So in other words, they are saying, implicit in this unsound argument, by the way, is that the proclamation is extant, is valid, and is clear, but somebody did not implement it in the correct way. They are saying so because it says, if Proclamation 34 of 2024 is lawful, then the conduct of the National Assembly is nevertheless unlawful. This is an alternative argument that your ladyships and your lordship are required to adjudicate according to them. So in other words, remember in the matter of Windhoek municipality, one of the matters where I will remember the name is about what you should do with an alternative argument. The court, including in Hashagen, is that you must, if the main argument fails, you must go to the alternative argument. So this issue is a live issue according to IPC, which is if the proclamation is lawful and extant, then somebody is guilty of committing an administrative error, which is, this is because the commission did not. This conduct is targeting the ECN, not the president. It's an implementation. IPC appeared to be confused with respect in monumental proportions. It says, this is because the commission did not permit extending voting across the Republic in contravention of paragraph B of the proclamation. Is this issue in the Supreme Court, your ladyship, or your lordship? It's not. And why should it be stayed when ECN is being accused? When will it be adjudicated? When will my client, the winning party, the victorious party, and its presidential candidate plan? Then you go to the next page. It becomes more clearer. Paragraph 57 rather, it says, so the commission was required, not the president, to ensure that extending voting took place at all polling stations across the Republic because this is inconsistent with the clear, and I highlight the word clear, wording of the proclamation. And in some breath, they are saying the proclamation is contradictory, it's not clear. Here they are saying, but President made a very good, on an alternative basis, and a clear proclamation, but somebody else, the implementer, the ECN, did not follow what the proclamation is saying. That is in area of a review, your lordship, your ladyship, and your lordship. And hence, we have taken a position in our paper, and we are entitled to have that dispute that we created in opposition, that appeared to be a review against a conduct, an incident, or an act, or a process by ECN. And there is a time period in terms of the necessary rules of this court that you must do it within 14 days, and so forth. When is it going to be decided? Why are they taking refuge from some cases not produced in court, all of a sudden? When is the court? So even if, your lordship, the court were to say, the Supreme Court were to say, the proclamation is valid, IPC has a dispute that it was not applied correctly. So this is your duty, your ladyship, your lordship. And an applicant cannot start running away when pressed hard from the case it brought to an adjudicator. So, therefore, we submit your ladyship that on the principle carefree and neatly set out by my two colleagues here, the matter cannot be stayed. In any event, both Justice Masuku and other judges of this court have stated that an application for stay require exceptional, that is a judgment at page 81 of the bundle, Your Lordship. 81 of the bundle. There is a judgment of Masuku referring to all the relevant cases. And it must not be a ready offhand power that the court can exercise. It must be only resorted to if the requirements are met, even if it is mero motu. The case that demonstrates that if a court mero motu raises an issue, it doesn't mean that the court, the jurisdictional facts or requirement must not be met. The judgment that demonstrates this is the judgment called S versus Stewie, S-T-E-W-E, and another. It is reported in 2019, volume 2, at page 359, Your Lordship. That is a judgment of two magistrates, regional court magistrates, who thought that because they were not appointed to be permanent magistrate, the Namibian law report, 2019, volume 2. The two magistrates were appointed to, on acting basis, to do cases in the regional court. They recused themselves from the matter because they said, the commission said, because they don't have LLB degree, they cannot be appointed permanently. When criminal matters were placed before them on acting basis, they refused and recused themselves. The Supreme Court in that judgment said whether it's mero motu, the requirement of the law must be met. So in other words, even if this case was, this issue was raised by court, the principles in the judgment by Justice Masuku that I refer to must be applicable. And the problem with the applicant who are widely embracing this question and want the matter to be stayed now is the fact that those requirements are not met in this matter with greatest respect. I therefore end by answering the question that what I'm saying, if the court were to stay the matter, somebody suggested 24th of March. Let me just demonstrate, 24th of February. Apparently, assuming we are coming back, remember this court, the Supreme Court has no power as a court of instance to deal with this electoral dispute, whatever the decision is. Are we coming back here with an order by agreement or whatever without the court adjudicating? It will be almost a month before the 21st of March. And the term of parliament, in terms of Article 50 of the Namibia Constitution, is 5 years. IPC in this case is not asking that, is asking the election apparently, and when I say election, that counts from the processes of nomination. Apparently it must be set aside, and then it goes quiet, per relief. It doesn't ask any other relief. In the Supreme Court, your ladyship and your lordship, you can see we produced the notice of motion. They are flip-flopping and they are doing it nicely. In the Supreme Court, they are saying, we ask you to order that a fresh election pertaining to the president be conducted. But in this court, they are not doing it. So all these questions show that this court, if it stays the matter, effectively speaking, and the requirement of adjudicating this dispute sooner than later, because of the rooming period before the 21st, is actually to abdicate your duty and shy away from a duty to determine the matter. Those are my submissions, my ladies and your lordship. Unless the court has any question, I will be happy to address it.
Questions? Thank you. Reply.
Oh, sorry, Your Lordship, in our bundle, we deliberately included the judgment of Hashagen, and I just want to inform court that we are relying at page 27 of our bundle, where Deputy Chief Justice dealt with that. If jurisdictional objections are made to a case, including we raised those jurisdictional points that a review is not available because time was not complied with, the court cannot postpone that question. It must decide it, otherwise the court will be deciding a matter without jurisdiction and so forth. Those are my submissions.
There are two large principal points I wish to address in reply. But before I do so, and those are legal points, before I do so, I do wish to have, by way of introduction, the IPC's response to the various arguments that we've heard. In my head, I've counted 14 misrepresentations of our arguments or the law concerning the main case and what this thing is about. 12 of them are utterly irrelevant to the question of whether there should be a stay or not, and I'm not going to address them. By further way of introduction, it is utterly bizarre that a respondent could ever, in any case in the world, in Africa, in Southern Africa or Namibia, oppose a stay. It is an applicant who wishes his case to go forward, and here a court invites the parties to say, why shouldn't this matter be stayed? And the applicant says, well, considering all the law and the facts, of course there should be a stay. And the respondents, for whatever reasons, which they don't explain, they talk about our rights, they talk about everything, they talk about Churchill. And if we want to talk about Churchill in proper context, they shall not raise the white flag in the court. They will continue to distort the truth on TikTok and Telegram. I've always learnt as a child, I don't want to talk about my children, when you point a finger, SWAPO, the president of SWAPO is pointing a finger at us, there are three pointing back. That applies to SWAPO, not to my client. They will not surrender. They won't surrender power, ever, until, I'll leave that until. Let me turn to my two big points. My two big points are, unfortunately, I've got to deal with this, and I didn't want to, but I'm going to have to. The first issue is I'm going to have to turn to the merits of a particular issue, which is our argument has been utterly distorted by the respondents. And I use the respondents in respect to all three. May I ask the court turn to page 320 of the record, which is the proclamation at stake here. Where's the notice of motion in this reading? You had it on 321 sees what is at stake. And I'll turn to why I say it's at stake. 320.
20.
And I'll show you.
Are we, let's just make sure, are we on ECN 15?
As it is at the court. Now this, sorry, let me just, I'll ask your ladyships and your lordship to hold this page because I'm going to turn to it in some detail. Unfortunately, I wasn't intending to, but now I'm going to have to. There is a dispute amongst the respondents as to whether this court can have regard to what is sought in the Supreme Court. You've heard that. The President and the Commission, well, the President says you can look at it and they refer to it. SWAPO says you can't look at it. Well, it's interesting because the court, in giving the direction yesterday, must have had regard to it, otherwise it wouldn't have issued the direction. Obviously. Correctly so. Let me read paragraph 1 of the Supreme Court Notice of Motion. I have it here. I don't know if the court has the Notice of Motion in the Supreme Court. In the Supreme Court, not in this court. No.
It's attached to the ECN papers, I think. Huh?
It's attached to the Commission's papers.
Yeah.
Page? There's 3 bundles here.
Oh, thanks to SWAPO's papers.
To SWAPO's papers. Sorry. I need to read it because it becomes crucial. But let me read it while I'm on my feet here. Prayer 1 of the Supreme Court case. Just find it. Just find it. Declaring proclamation number 34 of 2024 in violation of the Constitution of the Republic of Namibia. So it's a declaration that the proclamation, let's call it the extension proclamation, is a violation of the Constitution and in breach of the principles of Part 5 of the Electoral Act, number 5 of 2014, and as such unlawful and invalid and set.
581.
Thank you.
No, a moment so that
Yes,
the court
yes.
can catch up with
Much
you.
easier.
The numbering of these bundles seem to be off. We had difficulty with the pagination.
Just almost this applicant didn't do a good job here, but after the annex, yeah, look, ours we were given an index 581, yes, on our papers.
600.
We are there at page 600.
This is paragraph 1 of the notice of motion in the Supreme Court. I've started reading it, maybe I should read it again. And this is only in relation to the presidential election, declaring proclamation number 34 of 2024 in violation of the Constitution of the Republic of Namibia and in breach of the principles of Part 5 of the Electoral Act. And the important words are, and as such unlawful and invalid and setting aside same, or setting same aside. That's the relief sought in the Supreme Court. I know that His Lordship and Her Ladyship, Shiming Chase, has put this to our learned friends. Isn't the relief similar that is being sought in this court compared to the relief sought in the Supreme Court? And that's really the only issue that's at stake on this question of a stay, because if it is so similar, then of course the court would want to stay. And we heard about 5 or 10 minutes of this in long answer as to why this is not an issue with reference to Odocrol, which I'm not going to make any rude comment about the reference because we don't understand it. In the Supreme Court, there's a prayer that seeks a declarator and a setting aside of the proclamation. In this court, in prayer 1, there is a prayer that seeks a declarator of the same proclamation. And in prayer 4, I think the President's Counsel said that the court will see on page 3 at the end of the 4th prayer, and setting aside and setting same aside as unlawful and invalid with reference to the conduct of the election. Now, let me just say, bearing that in mind, let's turn to the proclamation itself, because then we will see what is actually at stake in these two cases. Is it the same? Is it similar? How close is it? And the various issues that really are at the heart of the issue on the stay application. ECN 15, it's got a heading, proclamation by the President, number 14, 2024. Does the court have it?
Just a moment. We're there.
And I don't want to show the court, it's not my task to show the court necessarily why this proclamation is unlawful. That's for the main case, here and in the Supreme Court. The principal stance is that it is unlawful because the President didn't have the power to make this proclamation. The court knows that. That's the principal reason why we are here. That on the 27th of November at 9 o'clock, the election came to an end. And thereafter, as a matter of principle and on the facts, it wasn't possible legally for the President to make this proclamation. We have a long argument, we've set out in our main heads of argument, and we've read our learned friends' arguments, and we submit that we have the better case on that. Then I'll argue in the main case. But our learned friend for SWAPO says that we've got an alternative. How dare we do that? And let me explain what the alternative is, because one will see the weirdness of what's actually going on. So what the President does, he says, under the powers vested in me by Section 64(1)(b) of the Act, we submit that Section 64(1)(b) certainly doesn't give the President the powers to do what he thereafter does in A and B, as a matter of principle. So what then happens is, In the answering affidavit, the President comes and says, yes, we didn't mention other sections, Article 12 of the Constitution or the common law or section something of the Interpretation Act, and they didn't have to mention it in here, but it's an extension of section 64(1)(b). Mostard's case in this court, I think it's this court or the Supreme Court? Supreme Court said you can't do that. If a president relies on 64(1)(b), that's what he relies upon, as a matter of principle. And he can't come along and say, yes, I do have the power somewhere else, but section 64(1)(b), it was a mistake or typo. He's bound by what he says he exercises. But leave aside that for a moment. Let's go on. What does he do? He says, under this power, I make known that A and B. And our learned friend for SWAPO criticizes us heavily for what we say about the difficulty that B has created. What the President did was, in B, he says, well, let's go to A. I have amended the original proclamation by extending the period for the election of the President and for election of the members of the National Assembly. So we know that's within this court's power, that issue. Referred to in that proclamation from Wednesday 9 o'clock, which was the previous night. Can't do that. Can't on the 28th say, I extend something that happened yesterday, that finished yesterday at 9 o'clock to Saturday night. Leave aside that for a moment. Let's go further. All of these arguments are there. He then goes on to say, now I've extended it till Saturday night at 9 o'clock, and B. Let's read B. The extension referred to in A is applicable to the polling stations set out in the schedule which were notified in terms of Government Notice 305 of 23 October 2024. What are those polling stations in the schedule to the Government Notice? Every single polling station in Namibia. Every single polling station in Namibia. The President says in his proclamation shall be extended till Saturday night. That's what he says. Can't get away from what he says. Did it happen? No. There were 36 polling stations of every station. Of this huge number of polling stations in Namibia, the President says every polling station in his proclamation, and what happens? So every person in Namibia knows. They just read the proclamation, clear wording. That's assuming he has the power, which he doesn't have. Assuming the President had the power to extend. What does he extend to? B. Every single polling station in Namibia. Can't get away from that. What actually happens? The people in Namibia and Windhoek, I don't know, not Windhoek, I think Windhoek's a bad example, but in polling stations throughout the country, read the proclamation if they can get in there. Whoa, we've got an extension. Do they get the extension? No. It's only 36 stations that stay open. That's the alternative argument. If he had the power, and if he exercised the problem properly, what happened? Nothing in compliance with this proclamation. That's the alternative argument. So to suggest that the alternative argument is one of those Johnny-come-lately, oh, well, if you can't succeed on the main argument, well, then you can't. No. We write on our principal submission, there's no power. And to the extent that there was a power under Article 12 or some other power, certainly not under power under Section 64(1)(b).
And both issues are in both courts.
And then this is an important point. The proclamation applies to both the presidential election and the National Assembly election. And both issues, the principal issue of the President's powers and the polling stations issue, is raised in both cases, in both courts, in both cases. How could it ever be just and equitable that this court could, for example, say, well, there's this polling stations issue in respect to the National Assembly, there's a powers issue in respect to the President. The Supreme Court is hearing the exact same issues, not similar, identical. But this court must give a judgment on that which is going to be coming up in a few weeks. And let me put paid to the SWAPO argument that says the following, which is about face. It's Alice in Wonderland territory. He says, if I understood it correctly, well, it would be useful for the Supreme Court to hear the views of this court on these issues, because it doesn't like to sit as a court. It doesn't, you know, in first principles, it shouldn't sit as a court of first and last instance on these types of issues. Of course, that makes sense if this court's decision wasn't subject to an appeal to the Supreme Court, which it would be. So whatever this court decides could go on appeal to the Supreme Court, and then the appeal court would be sitting with two cases, one as a court of first and last instance, and another as a court of appeal on the same, not similar, on the same issue. And this notion of obiter roche, that's what we will argue in this court, when the case is properly before the court. So we submit, it's bizarre that the respondents are opposing a stay initiated at in the interest of the court. Why would they be interested in opposing the stay? There must be some weird reason. Yes, sir? Yes, sir?
Not be suggesting bad faith against us with.
No, well,
with
as a matter of principle, when a respondent,
he cannot do that.
as a matter of principle, when a respondent opposes a stay suggested by the court, there must be some reason that is not apparent on first glance, prima facie. Because when the applicant support, I'm here urgently, and I agree with the court. When the court puts it to me, why shouldn't there be a stay? I say, yes, there should be.
Suggested a stay. The court invited arguments on the issue. So
And the wording of the directive is very important, because we noted it. We thought about it very carefully. The invited argument on why, I think the words are, it's like one of those return day rule miser type things. Why should there not be a stay, rather than should there be a stay? So the question of onus, etc., really, and it's, I'm not taking any issue about the words. I'm just saying we haven't initiated the stay. So the real issue is, I don't want to.
Respondents are entitled to present their opposition in as much as you are entitled
Absolutely.
to present your reasons without making a determination of where the court stands.
Absolutely.
We have asked all parties to address us so that we can make an informed decision.
Absolutely
They are
correct.
perfectly entitled to address us in opposition.
Subject to one question mark. Yeah, I agree with you. I agree with you entirely. Subject to this. There's a suggestion that we have the onus to bear to prove that there should be a stay. That's not fair. That's all I say. You've heard that. And the suggestions of, well, it's an extraordinary remedy, we bear the onus, and those kinds of arguments and we submit aren't appropriate in this particular context where the court raised it. That's all I'm saying. It's different to where, if we had come to court and brought an application for a stay, I accept their arguments. But to put the onus on us, etc. I want to make one last submission before I stand down. There is an interpretation of the Act presented to the court, which suggests that the court should be slow to grant a stay because of the wording of the various provisions. It's linked to the Standard Bank case, the National Credit Act case in South Africa, the judgment of Sutherland AJA, where there the court, you see, this is the difficulty. This is one of the 12 points that I'm not dealing with, but I need to come back to it in a particular way. There, the Supreme Court of Appeal, I'd be here the whole afternoon if I had to deal with every point raised. There, the Supreme Court of Appeal declined to exercise jurisdiction. And the Supreme Court of Appeal said the High Court was wrong in doing so, and the reason that they declined to exercise jurisdiction was because the magistrate had jurisdiction. So the High Court said, well, we won't exercise jurisdiction because the magistrate's got jurisdiction. The Supreme Court said, no, you have jurisdiction, you must hear the matter. That's got nothing to do with this case. This case isn't declining to exercise jurisdiction. This case is just delaying execution. So when it is suggested that effectively, and that was the word that was used, this court is denying hearing the matter, not at all. There's no effective denying hearing the case, it's just delaying hearing the case in appropriate circumstances. But these are the 12 points. Sorry, with respect, I didn't want to go into all of these because they are so irrelevant to the actual core issue. I just want to come back to this question of the jurisdiction of the court to grant the stay. So let me just, I made a note, and I just want to make sure that I've got it right. Yes, where is it in the electoral reference to the Constitution? Because what he said, if I understand, and again, I didn't quite, maybe I didn't understand the argument, and I apologize to my learned friends for not possibly understanding the argument. 167 of the Electoral Act, yes, this is the point. Yeah. This is what it said. 167.2 says, the Electoral Court has, in the exercising its powers and performance of its functions, all the powers of the High Court. Here's the Constitution. Conferred by Article 78.4. Sorry, do you have the Act? Sorry.
The
Constitution. Now, what I'm dealing with here is a reading. There was this whole issue of a long discussion by both of our learned friends about how the Act talks about the difference between courts and why it should go ahead in the way it's proposed in the Act. I just want to make this point. 167.4 says, this court, the Electoral Court, has in the exercising its powers and performance of its functions all the powers of the High Court conferred by Article 78.4 and 80 of the Namibian Constitution and the High Court Act. And if we turn immediately to 78.4, this is what it says of the Constitution. The Supreme Court and the High Court shall have the inherent jurisdiction which vested in the Supreme Court of Southwest Africa immediately prior to the date of independence, including the power to regulate their own procedures and to make court rules for that purpose. So what the Electoral Act has done has given this court the power in terms as to regulating its own process. That's the point that I wish to make. And regulating its own process, we would submit, includes not deciding until the Supreme Court has decided on the very issues that the Supreme Court will be deciding in a few weeks. That's the argument.
Submission. I didn't understand him to dispute the inherent jurisdiction of the court. I understood his argument to be that the inherent jurisdiction can only be exercised, for example, if there is a lacuna or if there is an aspect of the process that is not regulated. Can you please address us on that specific submission as well?
I'm not.
He doesn't dispute the inherent jurisdiction of the court, but he says it can only be exercised when there is a lacuna or when there is a rule or regulation that doesn't provide for a specific
Well, where's the rule that provides for a stay? That's part of the procedures that this court allows for. But then on that version we win because there's a lacuna.
I think the argument was that, so I may take it fair.
I mean,
The argument was that the scheme of the Act is such that when an electoral matter is brought to the electoral court, it must be speedily dealt with.
absolutely,
So any delay will be contrary to that.
absolutely, and we accept that. We accept that. We accept it, and now I have to accept that.
Yes. It
The-
is,
yes.
it is from that premise, as I understood him, to say that the scheme of the Act is that if the electoral court is seized with an electoral matter, speedily deal with it and don't delay.
I accept that.
Anything that points towards the delay, including the stay, will be contrary to the
I
legislation.
accept that. But the problem is they haven't addressed my point up front. None of them, on this question of the various permutations that follow from this court's judgment and the various permutations that happen. None of them addressed it. They just haven't. So what I suggest very strongly is the various permutations that are submitted up front could lead and would lead to an unspeedy resolution of the two issues before this court. And that's the point that I made up front, but they haven't addressed it. I said, what, and they look at me, suggested with frown. I said, what happens if this court makes a ruling, for example, dismissing prayer 1 of our notice of this notice of motion, and then the Supreme Court upholds prayer 1? How is that in the interest of having a speedy resolution of the matter? Then what happens to this court? Do we go on appeal to the Supreme Court and come back here? What happens? Because we'd have to do that. Because depending on what happens to prayer 1 in our case, prayer 4 might follow in a different way to the way the consequential prayers follow in the Supreme Court. So my submission is that the speedy way to resolve the dispute about the National Assembly election is to stay the matter so we know what the Supreme Court says about prayer 1. That's the real, and that's what I said up front. I didn't use the word speedy, and the point I was making with my various permutations, that's the just and equitable. And there's a suggestion this is not a court of equity, it's a court of course. But in regulating its own process, a court will do that which is just and equitable to the case and the party. But that's why I said that all of these submissions are part of my 12. I'd be here the whole day. And all I'm saying is, very simply, when the court gave us the invitation, we looked and the court used the word similar. I've demonstrated in terms, while the primary relief is not similar but the same. Once we know that, the consequences follow, as it pleases the court. There are two further last bitsy points. The one is, whatever the court decides on the stay, the costs of today should be reserved for some later period. Well, no, yes, put that way. And the second bitsy point is, I'm just wondering, and I haven't discussed this with my learned friends, or certainly with my learned friend for the LPM. It seems to me, I don't know when the court's intending to give judgment on the stay, but it seems to me, and I say this without just to assist the court rather than to assist the process going forward, that sometime before the main hearing, there should be a determination on the application for the LPM to be a second applicant, rather than on the day of the main hearing. I'm not sure when that should be. It could be this afternoon, on the question of the application to be admitted as the second applicant. We hear the heads of argument filed on it, determine whether the second applicant, but it's just a suggestion. I'm not asking for that relief, but it should be determined before. And this argument about whether they should be here, who they should be here, whatever, shouldn't distract from the main case when we argue before this court, whether it be now or some time in the future. That's the only point that I want to make about that joinder application. It should be determined sometime before the main case. And then they can come to court as the second applicant or as the eighth respondent, but let's do it in a seamless, let's call it proper fashion, rather than have the disputes of these kinds hanging around when we come to the prayers that we see, as it pleases.
Mr. Katz. Mr. Heathcote?
May I ask permission to make a statement or submission rather on behalf of the President as to the nullify they suggested?
Please allow Mr. Coulter to make his submission.
This is the court, my lady and my lord. I think the issue is determinable on the question posed by Justice Shiming-Shays. The correct answer is there is no lacuna at all, and I will demonstrate why. First of all, the court has asked the parties to address it on a simple question. The question is why the matter should not be stayed pending the judgment in the Supreme Court. That question arose in a High Court of Justice, Queen's Bench Division, Manchester District Registry, Mackendall Court, on Thursday, 14 June 2012, in the matter of Barnes against Black Horse Limited. And I've made copies. I didn't know that it would become an issue. I've made copies of that, and I want to hand up that judgment and copies to my learned friends. The facts are not important. Safe to say, the High Court was dealing with an issue also pending in the Supreme Court of the UK. But it's important what the court says at paragraph 19. Because the court say, secondly, one does not need to examine the position in a context. So one does need to examine the position in the context of my general powers to order a stay pursuant to CPR 3.12F, which have to be exercised with regard to the overriding objectives. Earlier on, when I addressed the court in Maine, I took the court to the overriding objectives, which is Rule 1.3. So there is no lacuna. Most importantly, my lady, there is no serious objection to grant a stay. We say so because the President, ECN, and SWAPO made no submission how they will be prejudiced if the matter is heard 2 days after delivery of the Supreme Court judgment. They made no submission whatsoever. And for that proposition, I rely on the same judgment at paragraph 25. The court said, of course, had there been some real or material prejudice as a result of the delay, other than the passage of time itself, the position might be different. There is no such evidence or submission before me. It has not been suggested that the additional delay is going to cause memories to fade or arguments of that kind. That will have been wholly unrealistic on the basis that if memories were going to fade, they would have faded long before this litigation commenced. In this case, pleadings have closed, heads of arguments have been filed on all sides. So there's no question of any prejudice at all. None has been advanced, and that is fatal. In any event, if one goes to suggestions have been made that the IPC does not seek to set aside Proclamation 34. The LPM does in both courts. Yes, yet. And that's what I'm saying. And this is why I made the submission, and I am glad that my learned friend for the IPC now also agrees that the joinder of the LPM needs to be determined before the hearing of this matter. Because if there is any prejudice, if the matter is not stayed, the LPM will certainly be prejudiced because we can't participate in an in the IPC application before we are joined, as it pleases the court.
I know, my lady, I see my learned friend is wanting to suggest that I think if I understood it correctly, that I made a suggestion of mala fides. Not at all. What I'm suggesting is this: it was I want to make two submissions. I make no submission that the president in the stay application or in the main application is mala fide at all. So let me suggest that there's no such suggestion. In the main application, I will accept, and I'm saying this up front now, that when the president issued the proclamation, he may have, I accept that he did so in good faith. Let's accept that. We're going to argue in the main case. This is important going forward. In the main, and this also goes to the question of the joint of the LPM. In the main case, we will argue that the president didn't have the power to issue the proclamation. He did so unlawfully, and that had a series of consequential effects, which relate to the further prayers. That's our primary submission. We do not submit that the president did so in bad faith, in issuing the proclamation. We do not submit that. In the main case, I'm saying. I want to reserve the right to argue that were the president in the main case to make certain arguments consequent upon a finding that he didn't have the power in the main case. I know this is very convoluted, complicated, but it's important. Then I might wish to argue that his new argument in the main case would be mala fide, but I'd have to see what he argues. But linked to that, no, it's very complicated because it's an important point because it goes to the heart of this case and the Supreme Court's remedial power. Because if this court strikes down Proclamation 34, it's then got to decide what to do. And the LPM has made certain suggestions which we do not agree with. And the President and the Commission and SWAPO also do not agree with. So that's why these issues, and we don't agree with the LPM on their remedial suggestion. I know the court wouldn't have had an opportunity to see all this. So that's why it's a little tricky, because we at this point would seemingly, we say seemingly, depending on what happens, would agree with the President and the Commission and SWAPO's, let's call it fallback position if Proclamation 34 goes. But that, depending on 115, I know there are other aspects to it. But that's why it's a little tricky, and that's why another reason why two things, this matter should be stayed, because the permutations and the various different are extremely complicated and extremely multifaceted. And this goes to the heart of the democracy of Namibia and the possible consequences of an unlawful election or otherwise. And the LPM's application needs to be considered because they ask for different relief to us as a consequence of the proclamation being set aside. Different. And we say substantially different. And how can I put it? I'll leave it at that. It's different. So that's why that goes to another reason why the LPM should be joined before we get into the main case.
My lady, last night when we received the note, I took instructions from the President of the Republic of Namibia, and after discussion with the legal advisors, we were briefed to argue that it should not be stayed. There is a flammable lot of people in this court and outside in social media, and that was the main cause. I take objection, whether he referred to it as mala fides. If my client, the President of the Republic of Namibia, says I must argue against the stay, and some person comes and he says there's something sinister in it, then I object.
Just 1 second for leave to. The only issue that I want to stand, my colleague is saying, SWAPO and other respondents, nobody whatsoever pleaded prejudice if there is a delay. It's not correct. Because I told Your Lordship that I'm acting for a victorious party, including its the president-elect, and there are processes and things that needed to do. But we did not even need to go there. And lastly,
Need to plan.
Yeah, exactly. I take strong exception to my colleague to come here and use that when we stood here, we said nothing about prejudice. And we're not talking about SWAPO parties, prejudice to be suffered by SWAPO party at all. We spoke on behalf of our members as the SWAPO party, as a litigant. We spoke about the Namibian nation, and we are entitled to do that. And my colleague, finally, it's not democracy. My colleague is saying our opposition to the stay is obstructive and may be subversive to democracy in Namibia. That's what he's suggesting. I take strong exception in that regard, particularly because I'm acting for SWAPO. Your Lordship, an incident happened in this very court on the 30th of May 1977 at 6 o'clock. 6 o'clock. Because of an order made those days by this High Court, a combatant of my client, Nduvuya Nangor, was executed in his fight for democracy in this country. Was executed. And that was to fight, amongst others, so that we have an independent and speedy trial to dispute. So we can never be accused, a SWAPO party, that when we say a dispute must be resolved, that we are acting in a manner that is subversive to the democracy we fought for. Those are my submissions.
I'm the last. I agree with both my learned friends, both of them, on two aspects. The one is, Mr. Heathcote said that quite correctly so, that everybody's listening. And when I make submissions about the president and his motives for opposing the stay, people are out there listening. Same with referencing my client in respect of the Churchill quote. It's inappropriate. As far as my learned friend for SWAPO says, I also agree with him. I didn't ever say that what SWAPO was arguing was subversive at all. What I said was, and I'll stand by this, that to the extent that the question of a speedy trial arises, my submission is to hear the case now rather than wait for the Supreme Court to decision is not in the interest of resolving the issue speedily because of the permutations I said, which is a far cry from the criticism that I've received in something that I didn't say, or my client didn't say. That's all. This court, we submit, in the interest of having the National Assembly election dispute resolved speedily, should stay for the reasons that are articulated this morning, as it pleases the court.
No further replies. I think everybody had their opportunity. Stage, the court is going to adjourn until 3 o'clock. Obviously, the bench need to discuss. We have had the opportunity of hearing comprehensive arguments, and we need to decide how we're going to proceed forward. I think everybody in court also deserve a health break. So we are adjourned until 3, when we will return to court. Court adjourned.
Was behind you. Yeah.
Resume after the lunch break. Council, apologies for the slight delay in resuming court again. We had some serious deliberations during lunchtime. And after having heard counsel and all the arguments for and against the issue to be stayed, and with being presented with all the authorities that you did, we would not be able to pronounce ourselves on this specific issue immediately. The court is going to reserve until Monday morning at 10, when we will have a judgment or ruling available to you. That would give us sufficient time to consider the arguments, consider the authority, and depending then on the outcome of that ruling, the court will then give further directions, be it for a hearing date, and also for the dealing with the joiner application, which is ancillary and which need to, we fully agree, the ancillary issues need to be dealt with before we hear the main application.
As the court.
So
As a court, please.
the matter is then adjourned until Monday morning, the 20th of January at 10 o'clock in the morning. Thank you very much.
May we be excused for turning up on Monday
Yes.
morning?
Foreign counsel is excused.
Yes, sorry, my lady, if I may ask, on Monday morning, we will not, I suppose, continue immediately with whatever happens on Monday. Was
We'll give the ruling and then immediately direct the
Yes, thank
way
you.
forward. Thank you. The court then adjourned.